Come back to the House Judiciary Committee on this Friday afternoon, January 23rd, and we are turning our attention back to H627 and an act relating to crime victims' rights and forensic cases. And we're going to an impacted citizen. So if Emily could join us. Thank you so much for being here. So yeah, thank you. If you just identify yourself for the record and proceed. Again, really appreciate you being here.
My name is Emily Perry, and I'm from Bradford, Vermont. Thank you all for your time today. I appreciate the opportunity to share my family's experience as you consider H627. On May 3rd, 2021, my sister Karina Rayom was murdered by our father. She was bringing him cookies in his house in Newbury, where we all spent our early childhood, and checking on his well-being, and he violently killed her. Karina was 38 years old and the loving mother of 4 sons. She was the kindest person. Thank you very much. She was the kindest person and my closest and longest friend. I had taken leave from work in October of 2020 and left my apartment to move in and take care of my mother in the last year of her life. My older sister Karina and my little brother James and I dedicated everything we had that year to taking care of our mother and helping her through the dying process. My mother spent the last 2 months of her life mourning the loss of her daughter. After a long standoff with the police, my father was taken into custody where he recounted the murder before being taken to prison. We were told at that time that he would either remain in prison or a psychiatric hospital for the rest of his life. The loss of my sister at the hands of my father devastated and traumatized my family and our whole community. We are still recovering. After all of that loss, in the beginning of 2025, my family experienced trauma due to the current justice system in place which handles these types of cases. On Thursday, April 17th, I received an email from the victim's advocate at the state's attorney's office saying that 2 weeks prior, the state's attorney agreed to not guilty by reason of insanity plea, and that on the following Tuesday, there would be a hearing and that my father would be released under some conditions, like going back to church and having someone regularly check on him. This is when all the trauma caused by the state began for me and my family. It is honestly a brutal story that I cannot fully tell in the time I have today. I will say that the plan at that time was to release my father, who had become mostly wheelchair bound by the time, back to his house, which was now unlivable, where he had murdered my sister, without telling his neighbors who had been traumatized, and without telling a single other victim than myself just days before his release. I had to notify my family, and they joined me in protesting the true horror of what's happening in my father's case. Our community rallied behind us, and over 100 individuals wrote to the state's attorney outraged. The following court hearings had every seat full with Vermonters who could not believe what was happening. We fought with everything we had in us to bring some sense to the state's attorney, the defense attorney, the Department of Mental Health, the judge, and with all of that with all of those efforts, the plan progressed to possibly a hotel room in Barrie, and then finally where he is now at, an adult housing facility with a 90-day order of non-hospitalization, waiting at any time to be fully released from the oversight of DMH completely. These 90-day ONHs are a slap in the face to victims and to justice. While I know there is so much long-term work that needs to be done to improve these complex systems, I want to highlight several specific issues that we hope the legislature will address through this bill. Victims' rights to timely notifications. From what I understand, victims are already legally required to receive notifications from their victims' advocates, but that wasn't my experience. Sometimes I received no updates from my victim's advocate, and sometimes I received them so late that I couldn't process or act on the information shared with me. My nephews and my brother were more often completely left out. What do victims do when the law isn't being upheld and they are not receiving even the bare minimum information required currently? There must be a clear and reliable mechanism to ensure that all appropriate victims can be designated as victims of record so that the critical information is shared in a consistent and timely manner. Victims' rights to having an advocate. I know that in this bill, it is mentioned that there could be a liaison for the mental health department. I think that this is a good idea, but I do not think it solves the problem that victims need to have advocates who can and do truly advocate for them. People who support victims emotionally, deliver information in a trauma-informed way, and ensure victims are heard in the court process. In our case, the mental health department wanted to wash their hands of responsibility in the case, so an advocate from their office would not be able to support us. The state's attorney's office also wanted to wash their hands of the case, and maybe that is why our victims advocate did not even notify us to the extent of the current law, let alone help to inform us or advocate for us in any way. Victims need to have victims advocates that advocate for them and are not employed by organizations whose interests might conflict with them doing their job. The Department of Mental Health's role is to treat individuals with mental health conditions. Trauma is a mental health condition, and victims of murder have a right to mental health, as well as those who committed murder due to their mental health conditions. The current system of care that the mental health department is modeling is causing trauma to victims, which are a vulnerable population whose mental health is already being taxed beyond belief. I hope that the mental health department commits to ensuring the mental health well-being of victims of murder and not just of those who have committed violent crimes. Lastly, I want to emphasize the critical importance of allowing victims to provide impact statements in these cases. When the state's attorney agreed to a plea agreement and decided not to go to trial, my family lost this right. When the defendants use competency to avoid or delay trials, those victims also lose that right. On Wednesday, I was here and I heard that victims everywhere say that being able to be heard in the process was the most important thing for them. My family and I fought very, very hard, and against all odds, the judge finally allowed us to speak. I am so grateful that we were finally allowed that opportunity. My nephews got to speak of the impact the murder of their mother had on them, and I got to speak of how that loss impacted me. When the judge finally allowed us the right that we would have been given if not for the plea agreement, all decisions had already been made. It was too late for our stories to have any impact on the outcomes of the case. And I don't just want victims to be able to tell their stories in court, which is a traumatizing experience in itself. I want the courts to have an actual interest in what those impacts are. Victims want to be heard, and in order for someone to be heard, someone must be willing to listen. I'm so grateful that I was able to be here on Wednesday and to hear conversations about victims' rights. It was humbling and heartbreaking to hear so many stories, so different from one another, yet all with a similar thread of trauma caused by the system which is supposed to be responsible for our safety. I am grateful for this opportunity to speak to you today, and I hope that these conversations continue to happen. My hope is that in the future, victims who have lost their loved ones to murder or mental health as part of the defense are not then traumatized by the state's handling of these cases. The current system is causing devastating harm to victims, and we need to change that. Thank you so much for your time.
Very much. Okay, take any questions?
Yeah.
Are there any questions? Go ahead, Angela, then Karen.
It's not a question, but I just want to say thank you so much for being here and sharing your story, and thank you for your framing of this issue, like a slight reframe that I have to say I haven't considered until you said it, which is that highlighting the mental health of victims and of everyone, taking the fullest picture possible into account. I think that's so important, and thank you so much for bringing that frame to this conversation.
Thank you so much. Yeah, when I was here on Wednesday, one thing I heard a lot was people talking about the re-traumatization of the court process, which is unfortunately an inevitable part. When you have this kind of loss, you have to accept the trauma and you have to handle that. And you have to accept that going to court and seeing, in my case, my father who had murdered my sister and be there with my nephews, that's traumatizing. And my takeaway though, was that there was an additional thing that was happening, which is a new type of trauma that was not just that re-traumatization. It was its own, how we were treated throughout the process. And that is really an important thing, I think, for mental health to consider. Thank you.
Karen.
Yeah, I don't have a question either, just appreciation for you being here and sharing your story, your experience. This is something that we are committed to working on just this session, and then the chair may share, like, whether it's this bill or there's other bills that are coming, I think hearing this and making sure we incorporate that feedback in your stories is important. So thank you.
Thank you so much.
Yeah, and thank you again. I'm sorry for your loss.
Thank you so much.
Thank you.
I believe next up is Judge Zone, who's joining us on Zoom. Thank you for being here, Judge.
Great. Thank you. My pleasure. Tom Zone, Chief Superior Judge. When we're looking at H 627 and you're looking at the rights of victims, I think it's important to let the committee know that victim input is critical to the work that judges do. We can see facts of a case, but the input of a victim tells of the human impacts that the facts cannot tell us. The victims' voices need to be heard, and the court needs to understand from the victims in cases the real impact on those harmed. As you just heard from Ms. Perry, that doesn't come from a record. That comes from a human being. And so when you are looking at these changes for notice, on, for instance, page 1, and you add that language about notice being given on lines 18 through 20, we support that. Right now, we have victims provisions in our statutes under Title 13 that provide for victims to get noticed by the state's attorney. And when we go out in a hearing, it's an important question is, have the victims been notified? What's their position? It's important for judges to have that. And so we support the concept, whether it's this bill or the other bill that Representative Dolan may have mentioned, about making sure that victims have notice so they can participate in the process. There is on page 2, on lines 6 and 7, a provision that says the court shall maintain a system for a person to file notice that the person is a victim in a proceeding. When a case is filed, the state's attorney's victim advocate, if there is a victim, will be entered as a party. They're entered into the case and they receive notices. And then under the procedures and statutes, they notify the victims. We do not currently have a process for notification from the court directly. And this provision, as far as a registry, doesn't talk about what happens as far as if somebody were to submit their name to some registry, what happens with it? Because if you look on line 8, the obligation still falls here to the state's attorney to provide notice. And subsequently in the bill, it talks about the Department of Mental Health having to provide notices. And so I don't know that subsection B is something that is necessary. And it also has the potential to lead to issues for the court as to who gets to file that notice. Are they truly under Vermont law a victim? And so having it come through the state's attorney as it currently does assures that we are making the individuals who are victims are the ones who get the notice from the state's attorney.
Can I ask a question?
Oh, yeah, go ahead, Karen. The question of.
Thank you, Judge, for being here. Just on that piece of it. So I'm understanding how this is adding the judiciary into the mix of it. And you're saying the state's attorney's office, they already have on file victims. What I was understanding that this is to open the door. So like, there's not the actual victim in the case, but maybe it's a family member or something like that. Is there a system that exists right now for that? Maybe that would be for the state's attorney's office. So
they would come through the state's attorney's office because the terms victim and interested persons are terms that are contained within Vermont law. They're different terms, but this section here would essentially doesn't have any limitation. In other words, anyone could say, I'm a victim and file something. And then is the clerk supposed to figure out if they truly are? Is the court? And I think that having it come through the state's attorneys adds the consistency. If someone says they're a victim and believes they are, and the state's attorney says no, they certainly can attempt to file something with the court to say we should be notified of that. But that keeps it with, again, with a consistency to what already exists for the arraignment, plea negotiations, and sentencing and those matters.
Thank you.
On page 5,
But before you go there, Judge, just another question. And maybe this isn't really quite captured in the bill right now, but I think I in part may understand why that subdivision B is in there. That there's probably some dissatisfaction as far as whether all victims are in fact receiving notice. Is there, if there's failure in providing notice, is there anything currently that victims can do as far as filing with the court? I mean, is there, in other words, is there any consequence or accountability if victims are not receiving notice?
generally, I have seen cases where victims have filed letters with the court saying that they were dissatisfied with the notice they've received. And in circumstances, the court can then bring the state's attorney in and the victim's advocate, defense attorney, and the parties in and say, what's going on? Why is the victim not getting appropriate notices? But as far as the ability of the victim to get the direct notices from the court, we don't do that. It goes through the state's attorney. It seems to me that to the extent that there are concerns about the victim's advocates providing appropriate and timely notice, that we should address the victim's advocates providing appropriate and timely notice. In other words, that is the expectation that the court has. And there are cases where I, on the bench, will say, we're not going ahead today because the victim hasn't received notice, or a victim may receive last minute notice and says, I need more time. And I'll say, okay, we're going to push that down and continue that because the victim hasn't received adequate notice. So it's always the goal of the court to make sure they get timely and adequate notice. And judges should be asking when they come out of the bench on victim cases, has the victim been notified? What is their position?
So that is discretionary by a judge, presumably, and suppose we could look at whether there's something we can do to urge. I mean, I know we don't like to mess with judges and prosecutors' discretion, but if that's inconsistent among judges, that's a concern, and we may want to look at.
I'm not aware that it's inconsistent, but I can take steps to assure that it is consistent, and I will.
Okay, all right, thank you. I think you were on page, I can't remember where you had.
Page 5. On page 5, in between lines 6 and 15, this talks about under section 4822, which is the discharge hearing or a hearing where there's not going to be a continuation. And it talks about on line 10, it says the right of the victim to be heard. And then a new sentence is added at the end that says the victim may express views concerning the offense and preferences for the person's placement and care, and the court shall consider the victim's testimony in its decision. I watched the testimony a couple days ago when I believe it was Jen Pullman was testifying, and she talked about meaningful opportunity to provide testimony. And I think it's important for the committee to understand what happens at the 4822 hearings and the limitations of the court. If the department, under Vermont law, a judge does not have the independent authority to order continuation of a hospitalization order under section 4822, when the Department of Mental Health does not seek its continuation. The Commissioner of Mental Health has the exclusive authority to initiate applications for continued treatment beyond the initial 90-day commitment. The significance of that is that if they give that notice and we have the 4822 hearing, the judge cannot say, no, you need to go and do that. And by adding language that provides that the court shall consider the victim's input as to the offense and preferences, you're setting up the victims to believe that what they are saying as to the preferences and what they're looking for, the court can consider, but the court doesn't have the ability to consider that at that moment. That's a decision that the Department of Mental Health has already made. And likewise for discharge, if the Department of Mental Health seeks discharge, the question for the court is whether the person continues to meet the criteria for commitment, specifically whether they remain a person in need of treatment as defined under Vermont law. In order to discharge someone, the court has to find that they no longer meet this standard to grant discharge. The discharge request also is something that is made by the Department of Mental Health. And I point this out because the limitations of what the court is looking at does not necessarily include what the statute would add for the victims and the court shall consider. And that sets up a tension. The tension being the judge will listen and the victim's statements, by virtue of the standards the court has to legally apply, can't really change the outcome. And so what we can see when that happens is you have victims who are frustrated. They feel the judge hasn't listened to them or what they have said hasn't made a difference. And no victim should walk out of a courtroom feeling that what they told the judge didn't make a difference. It does. Representative Goodnow talked about in plea agreements and the input for sentencing for victims. There are times where when that happens, judges will, the sentence, I can assure you, I have not changed, one of the parts of the calculus for a sentence is the impact on the victim. It impacts what the actual sentence will be because the judge can use it for that. A plea agreement. I've rejected plea agreements in circumstances based upon the victim's position. Those are uses that we can utilize. But in circumstances where the statute vests the authority in the Department of Mental Health to make a decision, and the judge can't override that, if the victims believe that they're telling the judge something and it's going to make a difference, and we all know that the law doesn't permit it to, the question I would ask the committee to consider is that fair to the victims? And is it fair to the system to lead to frustration? We've had quite a bit of talk over the past year or two about the sequential intercept model. And that, for those who aren't necessarily familiar with it, the sequential intercept model in mental health is we try to address mental health issues as early in the system. Well, if you looked at this circumstance like the sequential intercept model, it would be important for the victims to let the Department of Mental Health and have a process for them to let the Department of Mental Health perhaps know these concerns and their views before the decision is made to not seek a continuation, before the decision is made to seek discharge. And so I know that that's not necessarily what's in this bill or contemplated, but if the intent is to provide meaningful opportunity that may effectuate the end result, that again vests with the Department of Mental Health.
So the concept that you're suggesting is that victims should be heard from the Department of Mental Health on, location and those kind of things. That's because your hands are tied by the statute because DMH is making that decision. So I have a couple people will have questions, but before I get to them, I just had one other question first. And that is, so the Department of Mental Health and the standards that they have and that you are following or that we have in statute, it's not just statute that requires that. It's actually kind of constitutional. I mean, behind the requirement of least restrictive environment and actually that it has to be a threat to oneself or other that you're going to deprive somebody from liberty. That's not just statute. I mean, that comes from case law and constitutional law. Am I right about that? I mean, we don't, in other words, have a lot of room to say, all right, well, we're going to go into the DMH, to the department or the mental health law and significantly change that. that make sense?
It does. I don't want to wade too far into that, but I think it's
Sure,
safe to
sure.
say that there are a number of considerations that would involve constitutional protections and others that indeed do impact these decisions.
But there's nothing that presumably, and I won't ask you for your opinion on this, there's nothing presumably that would keep us from allowing victims to have some direct input to the DMH decision-making process, I would think. As long as not undermining the basics that they have to follow for case law and constitutional law. No, I don't need a comment on that.
Okay.
Because that's maybe asking you to. So Ken and then Karen.
Thank you.
Hi, Judge. I looked this up on online, what's happened, because this is another thing that just I just don't get it. But this guy was only in prison for 4 years, and then he was released.
Which guy? Just
Man we're talking about.
Oh, the person or that right.
Yeah, really hope you submit your paperwork so we have it on record. But he was only in there 4 years. I mean, is that the statute that we're under? I mean, how did this even get looked at in 4 years' time that he could come out? Is that like mental health comes in and then automatically by statute? How does that work?
If someone is found not guilty by reason of insanity, there are procedures in place under this chapter of Title 13 that the court has a hospitalization hearing. An order is made based upon that. Is the person a person in need of treatment? And the court makes an order from there.
Okay, so just let me back up. So what he was found not guilty by insanity right from the beginning?
That's my understanding from what Ms. Perry said. Yes.
Okay, so yeah, I'd like, do you mind?
Yeah, go ahead. Yeah.
It wasn't found, my understanding, he was found not guilty by reason of insanity in the beginning of last year. And that went to court for that plea agreement, but not until after that 4-year period. So he originally did, when he was first in prison, he did get had an expert forensic psychiatrist evaluate him and said that he was fluidly psychotic at that time. Most of that 4-year period, he actually spent still exhibiting some of those fluidly psychotic symptoms. My understanding is that we weren't given, because of his, protections for his privacy information. We don't have an exact clear line, but in a very short period, he came out of that fluidly psychotic state, and that is when they went to court. And so that same psychiatrist evaluated him, said he was no longer fluidly psychotic. They rapidly proceeded to go to court with the not guilty, somehow with that original finding, the not guilty by reason of insanity. And because he had become, for several months after 4 years of still experiencing that, after several months of not experiencing those symptoms, he was then deemed not to need hospitalization. And that's why we had an order of non-hospitalization, because he was not exhibiting the same symptoms. There was also a long list of conditions that could put him back into that fluid psychosis, and those things were not.
Oh, I'll get there. Thank you. So from what I just heard, he was found guilty by reason of sanity, non-sanity.
Not guilty.
Not
my
guilty.
understanding. Correct. That's my understanding.
Okay, so then it's statute that it's looked at after 4 years where an individual would stand about what's going to happen with them.
Correct. The question is at the moment that you have that hearing, does that person need to be hospitalized? Are they a person in need of treatment? Do they need to be hospitalized, or is there an order of non-hospitalization?
So my question is, how does that come up in 4 years? I mean, he only served 4 years and then it was brought back up. What's 4 years? Is that standard practice?
No. When a case is filed, the pretrial discovery and the parties go forward and they would address any mental health issues which may be in existence. They may seek an order, an evaluation for competency. The defense may seek an order and evaluation to determine whether the defendant Our experts find the defendant to be insane at the time of the offense. So the 4 years ties into what would have been the pretrial discovery period for the parties to move forward to get ready for trial. Had at that time, what the information that we've been told by Ms. Perry is that after they moved forward in the process, there came a point where the state's attorney and defense reached an agreement. The agreement was, instead of having a trial and having a jury determine whether or not the defendant was guilty or not guilty by reason of insanity, that the parties had reached a plea agreement where the state was agreeing that he was not guilty by reason of insanity. The not guilty by reason of insanity related to the date and moment of the offense and whether he was sane at that time. After that plea is entered, under Vermont law, a hearing is then held to determine whether the person needs to be committed to hospitalization or non-hospitalization, which relates to the time of that hearing or when the judge hears it. And so by virtue of the fact that the case was in dispute for that 4-year period, a lot happened. Not only the discovery, but apparently the defendant had his mental health had improved to a point where apparently the evidence was that non-hospitalization was appropriate. And so there's no standard for 4 years. That same result could have happened after 6 months or after a year if the parties had reached that agreement.
So this person gets released, and it looks like it was a very, like, says it's not in good health and all this, but he was pretty much able to go and do a lot of stuff. Like unsupervised, like if he had another whatever, I mean, something could happen. I mean, he already did something unbelievable to a family member. I mean, what's protecting those people? I mean, how do we have the laws that we're protecting those victims?
Under the statutes at that time, the court's obligation was to determine if the order of non-hospitalization was going to be entered based upon the evidence or the agreement of the parties. And that's the statutory framework that we have. The order of non-hospitalization is intended to address the mental health issues and address the safety issues.
Okay, thank you.
Yeah, and just look, Karen and then Tom, and some of this is being dealt with in S-193, the forensic facility. So that is something being looked at, Ken, in that other bill, which we hope to get from the Senate.
So just add to that, if you don't mind. That was the other question I was going to have. So this is just more of a reason why we need that facility so bad, right?
Arguably, yes, yeah.
Okay,
Yeah.
thanks.
Karen and Tom.
Yes. So bringing us back to this piece of victims being able to have voice. And I think that's what was trying to be accomplished here. And so I think I understand the situation. This is, I think, a great example of why we need to look at the whole system in these types of cases, because there's the mental health piece of it, which is medical health, and they're following kind of those rules and those lanes. They don't want to talk about the criminal and that piece of it. But then we have the court who has their set procedures of how they can handle things. So it just seems like these two different lanes. And I get why the court can't consider what the victim is saying. I also heard Jennifer Pullman say, because I think I asked her, like, that's going to be super frustrating for a victim to share and know that it isn't going to be used. And she shared, she understands that, and that it can still be powerful for victims just to share, even though they know it's not going to be considered. So one, I'm wondering if there's a change in language, but then I'm like, that is still setting people up that they're going to be heard and not acted on. But my question is are there any other points in this process where victims can be heard? Like, heard and maybe not acted on, but it's just, they want to get their story out.
The victim should be heard through the entire process. From the date that the individual is charged with a crime, under Vermont law, victims should be heard. They have a right to be heard. They have a right to appear at hearings. They are entitled to notice. The legislature has provided victims advocates to effectuate that notice and that connection between the judicial system and the victims. And so the process should be that they are heard the entire time.
Now, just to follow up on that. So say I'm a victim, I want to be heard. There's this hearing coming up. I know you can't consider what I want to say, but I just want to say it at court. Is there a way I can say that? Or what would I do? I don't know.
The language on line 10, a victim receiving notice pursuant to this subject has the right to be heard by the court. So I think you've added something there that is more than it had previously said about to submit a victim impact statement. And I think Ms. Perry indicated that in her situation, there was a question about whether the victims would be able to say something, and the judge allowed them to say something. That language would be very clear that victims can speak up at that hearing.
Okay. And the concern that you have is the last line of saying that the court will consider what the victim said, which is against law that's already existing.
Yeah, I mean, if the victim says something that is powerful, and the court says, the court is really moved by it and affected by it, if it doesn't tie into the specific factors and the law and statute that the court has to apply, the court can't use it. So will the court, I'll use air quotes, consider it? Yes. Can the court use it? No. And I appreciate Ms. Coleman's thought that, well, it lets people speak. And I absolutely, sitting on the bench and watching a victim go through that difficult victim's impact statement, speaking to the court, it's powerful and it's important. But I don't think there's one size fits all. In other words, I don't think every victim would accept the fact that they had their chance to speak and the judge can't use it. I think some victims would say, I had my chance to speak and they can't use it. Well, you're wasting my time. Why are you doing that to me? That's disrespectful. And so I think there's different views that people may have, all of which are reasonable. There's no one right answer. My concern is that if someone feels that the judge can use what they're about to tell them and the judge can't, I think that may lead that can be viewed as unfair to that individual, and that person can walk out and just feel the court system let them down.
May
And
I offer something? I'm just wondering, as I hear that was my original concern, and I'm wondering if it's something like, and the court shall consider the victim's testimony in its decision as the law allows, or something. I don't know. I just feel like, because I want to open the door for those victims that you said this could be helpful, but also be clear for those other victims, like it's not going to be considered in the way you might be hoping.
If you just say the right to be heard, that would seem to provide the opportunity to speak. We do have rules of evidence, rules of relevancy. If someone's going to talk about A and B, and we can only apply facts relating to F and G, there's concerns that can be raised. And so I get concerned when we have language that I think has the potential for people to look at the judges and say, you are not listening to me. You're not hearing me, when we are. But we just can't go in the direction someone wants, as opposed to circumstances, again, as I mentioned earlier, where we can, under the sentences, under plea agreements, continuances of cases, when a victims are saying we want to have this taken care of, a defendant's asking for a continuance, the victim's input there, things like that.
I think it was really helpful in understanding it.
Barbara.
Thank you, Judge. I'm still a little confused on, around orders of hospitalization. In this case, we're talking about it. I guess you would call it a hearing for an order of non-hospitalization, came at around the 4-year mark. So could one of these hearings be at 6 months, a year and a half, 20 months? And what determines the amount of time as far as getting a hearing for an order of non-hospitalization?
The trigger for an order of non-hospitalization is a finding of incompetence. In other words, the trigger is you either have a finding of incompetence or someone is found not guilty by reason of insanity, at which point the court then follows the statutory framework and has the hearing to determine whether there's going to be an order of hospitalization or non-hospitalization. So if, for instance, in a case where a defendant is thought to be incompetent, if there's a motion file, if there's a request for an evaluation file, the evaluation comes in, says the defendant's incompetent, you can be 60 days from the date of arraignment. And if that comes in and says they're incompetent, you're going to be having your hospitalization hearing within the next 30 to 60 days, almost guaranteed. And so the order of non-hospitalization or order of hospitalization would happen there. But it all depends on that determination of whether someone's competent or was insane.
I think I understand. So could somebody request a hearing to prove that the defendant shouldn't be hospitalized anymore? Can that be requested?
That if there is an order, that's what this 4822 is, a discharge hearing, and the Department of Mental Health has the ability to file and say we'd like to discharge.
I'll just come out and say where I'm going with it. Could a defense lawyer be opportunistic and say in this case where, for a few months the person isn't in, like, I don't know if the right term would be psychosis or not, or isn't psychotic for a short period of time for whatever reason, could a defense lawyer be opportunistic, get one of those hearings during that potentially short time frame and get somebody released from the hospital?
Under the criminal statutes, this is a discharge. The discharge hearing has to be filed under section 4822 by the Department of Mental Health. So a 4822 discharge hearing is not able to be filed by anyone. The Vermont Supreme Court has said that the Commissioner of Mental Health has the exclusive authority to initiate applications for continued treatment and likewise for the discharge.
Okay. Thank you.
I think
Barbara, that's right.
So Judge Sunny, I've been looking at the National Center for State Courts, who has a lot of information about reimagining competency hearings, etc. And I'm wondering, I know you are quite involved with the national scene. Is Vermont doing things really differently than other states? Are there ways that other places have been able to approach things, or resources that they have that you don't have?
Well, the short, easy answer is yes. The other states have different strategies. And the question is, are those strategies ones that we should bring to Vermont? And for a number of them, the answer is, again, yes. And that's why I know that I look at the Mental Health Commission. I know Senator Lyons and her committee has been working at S91 a few years ago and other bills. And so, yes, there's a number of things in other states. And we're trying, what I'm watching the legislature do is, what I'm seeing is the legislature is trying to reach out and say, what can we bring to Vermont that works in other jurisdictions? And so there's a lot out there.
And
You and I talked a little bit about trauma-informed courts and the work that you've been trying to do. Do you think there's anything related to when cases involve whether somebody's like, could we be doing more with the trauma-informed training for these types of cases?
You can always do more training.
Okay.
And so the short answer is, could we be doing more? Yes. Adequate training, appropriate training, it's critical. And we, as we've talked, the judiciary does have trainings, not only for judges, but for our staff on trauma-informed matters. And so can we do more training on those topics? Yes. We have a number of very important areas that we try to engage in training on for the judges. But that is one that we do have trainings on, and we try to have continual trainings on that on a regular basis to make sure that all judges are up on the best strategies and knowledge on how to make sure that our courts do take into account the trauma that individuals who are coming into our courts have experienced both outside of court and the potential trauma that comes from actually participating in the court process.
Angela, then Ian.
All right. I'm wondering if you can just say what the point of a 4822 hearing is. Because here's why I ask. I'm reading this and listening, and I feel like there's some, I'm confused, or there seems to be some conflicting information. I'm sure you'll explain it and it will no longer be conflicting, but it says, I understand, I've heard you say that only DMH, it is by motion or, the action of DMH that triggers this 4822 hearing. That the court cannot overrule the Department of Mental Health, determining, court cannot overrule the Department of Mental Health. But it also says, I'm looking at page 6, line 1, if the court determines that commitment shall no longer be necessary, it shall issue an order discharging the patient from the custody of DMH. So I think I'm just missing some information about what the court can and cannot do, what the purpose of this hearing is. If DMH is saying we should know, I don't know how to phrase it, this person no longer requires treatment, and then the hearing is held to determine if the person no longer requires treatment, and the court can make that determination. It sounds like a circle that doesn't quite meet or something, and it seems like there should be room for victims to impact what's happening.
Subsection C and subsection E shouldn't be separated the way they are, I think, for clarity's purposes. In other words,
Okay.
the question under subsection C is, when the Department of Mental Health files to discharge someone, what is the standard the court must find to determine whether they're going to grant the discharge or not? So then jump to subsection E. If the court determines that commitment shall no longer be necessary, it shall issue an order discharging. So if the department files and says, we want to discharge, and the court finds that the person is still in need of treatment, then
How does the court find that?
the court would have to have evidence presented at the time of that hearing.
And that could be evidence from if the state's attorney brings in an independent psychiatric professional to evaluate the defendant.
These
I
are
mean,
the
Yeah, sorry, go ahead.
Okay. These are the issues that the courts have to address as far as what are the parameters and who gets to bring in witnesses and who has the burdens. There is not a specific statute which clearly identifies that. And so I can't really opine on exactly that, who gets to absolutely do X, Y, and Z in that hearing, because that's something that can be up for debate for the courts to have to decide.
So on that list of potential witnesses, would we not put victims?
Well, the question is, if there's a hearing conducted on January 23rd of 2026, the question is, on January 23rd of 2026, is the defendant a person in need of treatment? If the court determines that they are, the court would not discharge them. The court would continue them in the custody of the Department of Mental Health. The Department of Mental Health, when the court commits somebody, determines if they're in their custody. The court department determines where they're hospitalized, where they're living, and those types of issues.
So can I to clarify a little bit as well, when you say it's a person in need of treatment, the key is that the person has a mental illness, and as a result of that mental illness is a danger to themselves or others. And it's because
Correct.
it's wrapped up into that mental illness, and as a result of mental illness, that's where you have to defer to the Department of Mental Health.
Correct.
And
A person
doesn't have the expertise on that really being the heart of the issue.
And that's the sole authority of the system.
But it's
Because
not
it-
full authority.
And it's not
To determine what,
right?
well, you don't know.
If other witnesses can be brought in, then it's not necessarily DMH making, I mean, like, they're making that call to kick off the hearing. But there are other potential influences.
Yeah.
Professional, like
there,
licensed, what have you, maybe, I don't know, apparently there's no list, but it just seems like, at first blush, it's like very clear, DMH makes the call, the court can do nothing about it, but I don't think that's what I'm hearing.
well, if you look at it, there's two separate issues. One is, let's say, whether there's going to be a request for a continued order. If there's no request, that's it. If DMH doesn't request it, Representative Arsenault, the statements don't impact and can't impact that, because the court is powerless to say, oh, what you just told the court was powerful, and we agree with you and we should go forward. We can't. So in the discharge hearing, the question is the information that the court is receiving information that can assist the court in making its decision to determine whether the person is suffering from mental illness, and as a result of that mental illness, their capacity to exercise self-control, judgment, or discretion in the conduct of their affairs or social relationships is so lessened that they pose a danger of harm to themselves or others. That's the person in need of treatment. And so the court is looking at the person in need of treatment.
So I don't mean, I guess we're gonna pivot, I'm gonna pivot us a little bit because I have a question about something on, so we're on page 5 of this 10-page bill. But I wanted to say quickly that I feel like this is really helpful. Judge, I really appreciate like us being able to sort of explore this, because if we have another bill that we're going to be working on in the same area, it is really complicated and there are a lot of different areas that are sort of intersecting here. So I think the conversation is great. My one question to you, Judge, is on page 5, the bottom, line 19 to 21. So this is the basically, if we don't give proper notice to a victim, the court shall continue the hearing. So what I wanted to know was, I really like this language, and I think that the sister language in 13 VSA 5321 should also say this. And I'm curious to what your thoughts on that are.
That's a policy decision for the legislature. But what I can tell you is that under 5321, and what Representative Goodnow is talking about, is that there's language in the victims notification statutes that say the court won't continue things just for failure to give the notice. And I can tell you that I can speak for myself, and I know other judges who say, well, we're continuing it. We don't have to, but we're going to, because the victim should receive notice. So conspicuously absent from my comments today was any objection to the language in section on lines 19 through 21 that you just referenced, Mr. Goodnow. I understand that. I would only note that there may be a circumstance where and you might want to tweak the language that they've tried and with good, good faith efforts, because I do know there's times that you can't notify someone.
Yeah.
But the idea,
Okay.
but
Sorry.
fundamentally, that's a legislative policy decision, and I certainly understand why that would be a direction the legislature goes in.
Great. Thank you.
All right, so moving on then, I'm sure that you have some comments on line 8 of page 6, unless I'm completely deluded from past testimony regarding words like timely.
I think timely is broad enough
Oh,
that it provides us, it provides enough flexibility to be used without tying people in, and it sends a message that we want something done in a manner that is going to be, I'll use that word, meaningful again.
so is that a word that's frequently or at all used where you statutorily have to do something in a timely manner?
Again, I think it's a pretty subjective term.
Right, it's not promptly, which I think promptly is quicker than kindly.
Yeah, timely would I think brings into it components of to consider what the purpose of the notice is, and if you give the notice, does that effectuate? Does the person have the adequate time to prepare or get ready for the hearing or to get there?
Okay, yeah. Anything else on any of the other parts of the bill? Covered?
I have nothing further. Thank you very much. And if you have any additional questions, please don't hesitate. Let me know.
We will, absolutely. I'm sure we will be visiting with you much more on this subject matter when we see the forensic bill from the Senate as well. Thank you very much, Judge. And
Thank you,
have a
Judge.
great
Thank you,
week, Judge. Have a great weekend.
Thank you very much. Have a great day.
Heal fast.
We're trying. Thank you.
So do folks need a 5-minute break before we go to Kim McManus, or do we just want to be done?